Welcome to Harper Macleod's first ever Franchising Fridays podcast series. To start us off, David Kaye, partner and head of retail and franchising at Harper Macleod, will take us through understanding the legal aspects of franchising. We hope you enjoy it.
Did you know that according to a recent British Franchise Association NatWest survey, there are 44,200 franchisee outlets in the UK? 621,000 people are employed in franchising, and 97% of franchisees report profitability. Franchisee satisfaction with their franchisor is currently sitting at 91% and has never been higher. So, what is franchising law? Is there such a thing as franchising law? Unlike many other countries throughout the world, franchising is not regulated in the UK. Instead, it's governed by a number of different aspects, such as general commercial law, the laws of contract, some corporate law, property, and intellectual property. Some specific acts of Parliament, for example, the Trading Schemes Act 1996. It's also made up partly of European and UK competition law, court judgments. And then there's the European Code of Ethics for Franchising, which has been adopted by the British Franchise Association. All in all, it boils down to best practice. So, if you're looking to grow your business through franchising, what types of legal documents will you require? The first would be a confidentiality, or sometimes it's called a non-disclosure agreement. This is a relatively short agreement, and it protects the franchisor from anyone disclosing its trade secrets. It's pretty important at the outset to ensure that one of these is signed before the franchisor begins to pass on confidential information. The second document is called a deposit agreement. Normally, a franchisor would agree to reserve a territory for a franchisee, perhaps whilst the franchisee goes away to find appropriate premises or secure bank funding. And that period of time could be 3 months or 6 months, but it's usually recorded within a deposit agreement where the franchisee agrees to make a payment to the franchisor by way of deposit, and typically £2,000 is a normal sum. And then that sum will be held by the franchisor until either the franchisee goes ahead, in which case it's deducted from the initial franchise fee payable, or if the franchisee decides not to go ahead, then usually the fee is refundable by the franchisor, less the franchisor's proper and reasonable costs. The next document that's important to consider is a trademark license agreement. Before you franchise your business, you need to ensure that you have a properly registered trademark. And once you have that, it's quite common for the franchisor to set up a separate company to act as franchisor, but protect its intellectual property, including its trademark, in the core business. Therefore, what a lawyer normally prepares is a trademark license agreement between the owner of the business and the franchisor company that's been set up for franchising, and that's called a trademark license agreement, allowing the franchisor to use the brand and the IP for the purposes of franchising. Another document that's critical is the operations manual. This really is the franchisor's Bible on how to run the business, from the moment the franchisee opens up in the morning until the franchisee closes up at night. It's a carefully prepared document that most franchisors will compile with the help of a franchise consultant, setting out all the really important aspects involved in running this system. But by far the most important document is the franchise agreement itself. Now, this can quite often run somewhere between 40 and 50 pages long, and it's usually very one-sided in favour of the franchisor. After all, the franchisor has spent a lot of time, effort and money in developing its business, and the franchise agreement is where the franchisor's protections are all set out and documented. So what I want to do today is to talk you through some of the key terms that you'll find in a franchise agreement, and perhaps explain a little bit behind why these terms are used and why they're drafted in such a one-sided way. So let's start at the beginning of the document, where we'll have set out what's called the key terms of the relationship. First of all, you'll have what are the rights granted. So what's a franchisee allowed to do? Does it have an exclusive territory? And where is it allowed to operate? Secondly, there'll be the various fees set out. There's an initial fee, a sum payable. It can range from sometimes as low as £5,000 all the way up to £35,000. It depends on the type of franchise, but that's called the initial fee. And in exchange for that, the franchisee receives what's called an initial franchise package. And that will include training on the system. It may include franchise stationery, sets of uniforms, possibly some other equipment. Then there's the management services fee. And this is quite often recorded as a percentage of turnover excluding VAT. And that percentage is payable every month by the franchisee to the franchisor for management services. It can be a fixed fee, but this is not common in what we know as a business format franchise. Typically, a management services fee will be somewhere between 8 and 15% of turnover, but that's not always set in stone, and you do see these percentages being significantly higher from time to time. The franchisor is also entitled to charge a national marketing levy or national marketing contribution. Now, this is usually a small percentage of turnover, typically between 1 and 3%, payable each month to the franchisor, who is then entitled to market the franchise system nationally in whatever way the franchisor chooses to do. Another key term of the relationship is how long will it last? What is the term? And again, it's common to see a 5-year term subject to renewal, but there are terms that are longer, and sometimes you'll see 7 or 10-year franchise terms. The franchisee has a right of renewal at the end of the initial term, and for example, let's take it as 5-yearly. However, the franchisee has to have performed to the satisfaction of the franchisor during that 5 years, and there may be targets that the franchisee has to achieve to be allowed the opportunity to renew. Since there will also be conditions attached to renewal, and the franchisee will have to serve a notice, quite often between 30 and 60 days before the end of the 5-year period, requesting another franchise term. The franchisor has the ability to request that the franchisee upgrade its vehicles or equipment, perhaps refurbish premises, and other conditions that it thinks are appropriate before renewal will be granted. But the franchisor can also say no. If the franchisee is in material breach, or has been in material breach at any point throughout the 5-year term, or is in any type of breach when it comes to renewal, the franchisor can turn around and say, no, you're not getting a further term. Also recorded at the outset is the territory. And usually this is done by way of postcodes. Sometimes a territory map is also annexed as a schedule to the agreement. So it's very important to ensure that all of the relevant postcodes are properly documented in the franchise agreement. And targets. The franchisor is entitled to impose reasonable minimum performance targets on a franchisee and ensure that the franchisee achieves those targets. Usually the franchise agreement will contain a clause which sets out the necessity of the franchisee to prepare a business plan, both at the outset and to have it updated once a year with input from the franchisor as well as a franchisor's approval. And the franchisor can actually impose targets on the franchisee within the business plan. The agreement will usually say that in the event that the franchisee does not achieve those targets, Then the franchisor and franchisee will sit down, discuss perhaps why they've not been achieved, set new targets. It might be that the franchisor gives the franchisee further training or additional support. But ultimately, after a further period of time, which can often be 6 months or so, if the franchisee has still failed to achieve the targets, then there are a number of options available to the franchisor. This may be to reduce the size of the territory. It may be to remove exclusivity from the territory. And ultimately, the franchisor has got the right to terminate the agreement. So, let's now look at the franchisor's obligations as set out in this franchise agreement towards the franchisee. It's a relatively short section where the franchisor is obliged to provide certain things initially. These are called the initial obligations. That will include initial training, the provision of a startup package, and sometimes equipment will be included, the supply of an operations manual on loan and clearly to be treated as strictly confidential, and perhaps some assistance with the franchisee's initial setup, even including a marketing launch, but not much more. And on an ongoing basis, the franchisor's ongoing obligations are again relatively few. They will include ongoing training and development, updates to the operations manual and procedures in implementing the system, perhaps the supply of products and services to the franchisee, whether directly from the franchisor or through its nominated suppliers. And usually there will be a helpline for support that's available to a franchisee, and this will be documented as an ongoing obligation. Once the franchise system is large enough, the franchisor may also be obliged to organise an annual conference and perhaps regional meetings at its discretion. However, the longest section of the agreement is what the franchisee is obliged to do in relation to its obligations for the franchisor. And this will be split into various different sections which can be very detailed. So there usually will be a section on the supply of products and services to customers, a section on the importance of recruitment, training and supervision of employees. If premises are involved, then there will be a detailed section on locating suitable premises, making sure that the franchisor approves of these premises, and it may record whether or not the franchisee is to take the lease of the premises itself, or sometimes a sublease from the franchisor. There will also be a section on vehicles, because the franchisor may require a franchisee to buy or lease a suitable vehicle and to have appropriate livery on the vehicle. Usually there'll be a section all about the intellectual property, the branding of the franchise system, and the importance of maintaining that branding and notifying the franchisor should there be any challenges to the trademark. There will be a section about the internet, and commonly the franchisor has its own web page with a separate page for each franchisee in the system. So it's not unusual for a franchisee not to be allowed to have its own website, but to be obliged to use the page from the franchisor's landing page. There may well be a section on social media, and the franchisor may have a social media policy, and it will be all about complying with the brand guidelines. There should be a section in the agreement on accounting and reporting requirements of the franchisee. The franchisor is going to want regular reporting. It may reserve the right to access the franchisee's accounting system and have a look at the relevant figures. And it will certainly want accounts to be prepared and finalised within a set time period, and usually to receive copies of the accounts, and quite often of all VAT returns. And there'll also be a section on compliance with the operations manual, which of course will be very strictly enforced. So what happens when a franchisee wants to sell its business? And there's a separate section in the agreement which regulates the franchisee's right to sell. The franchisor can sell or transfer its obligations under the agreement whenever it wants, to whomever it wants, provided the new franchisor complies with the terms of each franchise agreement. But a franchisee's right to sell is very different. Firstly, it must obtain the franchisor's prior consent before it sells, and the franchisor can buy the business back. This is called the right of first refusal, or sometimes preemption. And what this often says is that the franchisor has a period of time, usually around 30 days, to decide whether or not to buy the business back at the same price or at market rate as the franchisee has been offered and on the same terms and conditions. If the franchisor does not exercise its right to buy back, then the franchisee is entitled to proceed to sell the business, but subject to the incoming franchisee meeting all the franchisor's required criteria. And that will include completing training. It may also state that either the franchisee or the incoming franchisee have to pay for the costs of the franchisor, legal and administrative costs, the cost of training, and if the franchisor has introduced the purchaser, then quite often there's a separate commission on the introduction of a purchaser, and that can be 10% of the sale price. The agreement also contains sections about death and incapacity of the franchisee. Now, sometimes, and quite frequently, franchisees set up their own limited company to run the franchise business, but there will be a principal, the main person or people, who will be responsible for operating that business. And these will usually be the directors, sometimes also the shareholders of the franchisee's company. And if the principal dies or is incapacitated during the agreement, then there are clauses that regulate what's to happen. The franchisor usually provides that it can appoint a manager during the interim period to run the business, with the franchisee or its next of kin meeting the costs of that manager and the franchisor's administrative costs in addition. But there are time periods set out in each franchise agreement whereby, in the event of death, the franchisee will have next of kin, known in Scotland as executors or trustees, and they can appoint a family member or another party who's acceptable to the franchisor to step in. But of course, that person has to meet the franchisor's criteria in the same way that they would do if the business was being sold to them. In the event that within the set time period, usually 6 months, there hasn't been somebody nominated or somebody that's suitable, then the franchisor can require the franchisee to sell its business within a further period of time, again often 6 months, failing which the franchisor has the option to buy the business back itself or simply to terminate the agreement. In the event of incapacity, a time period exists whereby, let's say for 30 consecutive days, a franchisee is unable to run the business, or for a total of 60 days in any period of 12 months. Then the franchisor, beyond being able to engage a manager to run the business during this period, can then say to the franchisee, you now require to sell the business. And a time period of usually 3 to 6 months is again imposed for the franchisee to do so. The termination clauses in a franchise agreement are very one-sided, normally only allowing the franchisor the ability to terminate. Now, there may be certain common grounds for termination, such as failing to pay sums due, material or repeated breach of the franchise agreement by the franchisee, providing false or misleading information to the franchisor, damaging the brand, failing to obtain franchisor's consent, perhaps buying from non-approved suppliers, bankruptcy or insolvency, and even suspending or threatening to suspend trading the business. These will usually allow the franchisor the right to terminate immediately and to pursue the franchisee for its losses. So if, for example, this happens within 2 years of the franchise term, then the franchisor has got 3 years of unexpired term in which it's entitled to receive a management services fee, and therefore it can usually seek to recover these losses from a franchisee. There may also be a number of what we call minor breaches, where the franchisor is obliged to send the franchisee a notice to say, remedy these breaches, or else I will then terminate. But a franchisee can't terminate a franchise agreement unless it's prepared to do so under common law and go to court to prove the breach and then prove the loss. It's a far more difficult situation that a franchisee encounters than that of the franchisor. And then the agreement will cover what we call the consequences of termination. And apart from the franchisor's right to recover loss, including this loss of anticipated earnings, the franchisee will be obliged to cease to trade, to cease to use all of the branding, all the IP, to return the manual, and to abide by restrictive covenant. Now, these are very standard in franchise agreements, and they are quite enforceable. 12 months is known as the normal period where a franchisor can restrict a franchisee from not competing in the territory, perhaps in the territory of another franchisee, and similar restrictions from non-solicitation of employees, not approaching suppliers, and the same with customers. Each franchise agreement will be slightly different, but usually these are well-drafted clauses that are enforceable by a court. They're different from employment covenants, where usually somebody is entitled to earn a livelihood and you can't deprive them of doing so. In franchising, a franchisee has purchased a business which is able to sell, and therefore courts will usually enforce a 12-month restrictive covenant. Towards the end of the agreement, we have a significant number of general clauses, or as we call them in the legal trade, boilerplate clauses. But nonetheless, these are extremely important. There is usually a section where the principal guarantees and covenants the performance by the franchisee company. And it's a very enforceable section. It may even be a separate form of guarantee that the principal is meant to enter into at the outset. There will be an indemnity clause where the franchisee agrees to make good to indemnify the franchisor against any loss that it sustains. And there will be several clauses called acknowledgements. These will be acknowledgements, for example, that the franchisee has no right to the system, that no guarantee or warranty has been provided by the franchisor, that the franchisee has been advised to seek independent advice and has done so, that it's using its own personal judgment, and that it's a business which contains risks. And it's important that the franchisee fully reviews and understands each of these acknowledgements before they sign up to the agreement. Franchisors are always encouraged to ensure that franchisees seek independent legal advice, ideally from a franchising lawyer. There'll also be a clause called the entire agreement clause, which basically says the franchise agreement and the manual contain the entire agreement of the parties, and that no other documents can be relied upon, so that if the franchisor has given the franchisee a prospectus or a set of projections or any other correspondence, the franchisee cannot rely upon them unless they are annexed to and stated to form part of the agreement. There should be an alternative dispute resolution clause in a franchise agreement, perhaps saying that in the event of a dispute, the parties will have an informal meeting, try and resolve the differences. But if not, that they'll then proceed to try and resolve the dispute through either mediation or arbitration. The British Franchise Association have appropriate schemes that members can use in the event of dispute resolution being necessary. And there'll be a clause about the governing law, and it will usually say, if the agreement is drawn up in England, that it's English law and the law of the courts in England and Wales are to apply. If it's drawn up in Scotland, then hopefully it will be Scottish law and the Scottish courts. Now, the differences between Scottish and English law, there's some terminology differences, but largely they're property related. And it will be important for a franchisee to go to a solicitor who understands property law and make sure that the appropriate differences are contained in the agreement should the property be in Scotland. Finally, it's important just to touch on the role of the British Franchise Association in the UK. They are the trade body for franchising in this country. They are the only source of governance for franchising, and as I previously mentioned, they adopt the European Code of Ethics. Courts have deemed their guidance to be very useful in determining cases, and it would always be advisable to use British Franchise Association accredited advisors. They understand franchising, they can guide franchisors and franchisees with genuine expertise. In summary, these are detailed and one-sided documents, but for a very good reason, and it is important to seek proper professional advice, whether or not you want to expand your business through franchising, or if you're a franchisee looking to take a franchise of an already established system.
So, that concludes the first of our 4-part Franchising Fridays podcast series. For more information on how our team can help you with franchising, you can find our services on harpermacleod.co.uk/franchising. And if you have any questions, please do get in touch. Thanks for tuning in. We look forward to you joining us for part 2 of our Franchising Fridays podcast soon.